Sunshine State.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are back here live again with FLA Law. It is your Tuesday evening legal call-in talk show tonight. As you know, we've been doing this every Tuesday at the 5 o'clock hour. As you're driving home from work, you can call in right now and get your legal questions in. My name is Jacqueline Bryant, and I'm one of the attorneys at Perinick, Caulfield, Averill, and Noyes. And today I have a co-host here with me who is one of my colleagues. You can go ahead and introduce yourself.
This is Daniel Havican. I'm an associate at Perinick, Caulfield, Averill, and Noyes. Been practicing personal injury law for 3 years now and been at this firm for the same amount of time. So happy to be here.
Awesome. Thank you for joining us. As you guys know, Daniel is a pro. He's been with me most of the time here. And Matt, of course, is out this week. He's on spring break with the rest of the CCC crew. So hopefully they're enjoying their time off, and we'll see him again on another day.
And I'm sure he's still ecstatic about the race start, 10-0. It's insane.
So well. I mean, when's the last time they've started off the season?
I think I read it's the first time any MLB team started 10-0 since
Really?
like 1987.
Oh my God.
So it's been that long. Yeah.
So I knew they were making records for themselves, but I didn't know it was the entire MLB record.
Yeah.
Awesome. Okay. Well, obviously that's great for the Tampa Bay area. We've got that winning spirit going on, but of course, this is our legal live and call-in show. So I want to give you the numbers so that you can call in. It is 727-441-3000. That's going to be the call-in number for tonight for you to get your questions in. But we are also on the socials. So we just started something new last week, and hopefully you can see us. We're waving. We're on Instagram Live tonight, and we're also on Facebook Live. So if you're on Facebook, you're on Instagram, go ahead and give us a listen, drop a comment, ask any questions you might have as far as legal, and we will answer those for you. You've got Daniel and I here to answer those questions.
We'll be scoping out the feeds. So if you got a question that you'd rather just type out, we'll be there and we'll be able to see those and answer those.
Looks like we've got some viewers on both Instagram and Facebook. So those that are watching, please like, share, comment, let others know that we're on live tonight. So if they have questions, maybe they don't know us, but you know us, so you can share it with your friends and family, and they can get their questions answered as well. We love the engagement. If you're looking for us and want to try to find us, it's Perinick, Caulfield, Averill, and Noyes Injury Lawyers. That's what you can find us under Facebook. Perinick spelled P-E-R-E-N-I-C-H. But if you're looking for us on Instagram, which we are live on there too, it is PCAN Injury Lawyers. So that's the abbreviated version, right?
Yeah. Most people call us Perinick Caulfield, obviously, but exactly. Yeah, some people just rather just say PCAN. So.
Exactly. So as Daniel mentioned, we do personal injury law, and those are the types of questions that we tend to answer. But we, of course, open it up to whatever you need and whatever questions you might have tonight. We had some Social Security questions coming in last week, some workman's comp. So keep them coming. Whatever it is that you have questions, feel free to give us a call at 441-3000. If you're outside of our local area and you want to call in, feel free to call us at 1-866-826-1340. That's the toll-free call-in number. So with that being said, I did want to kind of jump into what our topic's going to be tonight. And I think it's interesting because it kind of applies to any litigation, right? So it doesn't necessarily have to be a personal injury case per se, but we could be talking about any type of like a family law litigation if you're in some sort of dispute. It could be a probate matter that is going on and it has to be litigated. But whatever the case may be, if you find yourself in a civil lawsuit, I think these tips tonight that we're going to be talking about are going to be helpful, right?
Yeah, absolutely. Because anytime you find yourself in litigation, you're going to be looked at underneath a microscope, right, from the other side. So absolutely, any type of civil case, these tips are going to be helpful.
Exactly. So I want to dive right in and talk about depositions. So that's a word that everybody may not know what it is. So first, let's just tell everybody what's a deposition and how does it come into play in litigation?
Well, a deposition is essentially an ask and answer format when the opposing counsel has the opportunity to depose our clients is what most likely when that arises. We would take the depositions as plaintiff attorneys of the defendant, but they have the opportunity, the defense counsel, to ask you questions and you are under oath answering those questions in a truthful manner.
Right. So that's exactly what it is. And that's the key, is that it's under oath. So when you start out, you're being sworn in, and it's almost like you're in court where you see on TV where you hold up your right hand and you swear to tell the truth and nothing but the truth.
Yeah. It's your direct examined, but it's before you get to a courtroom.
Exactly. So it's pretty much the same deal, except you're probably going to be at your lawyer's office, or you're going to be at a court reporter's office, or you might even be by Zoom these days. It's not necessarily always in person. But a lot of people are concerned when they get that letter in the mail or that subpoena comes from the other side and it says you've been subpoenaed for your deposition or your deposition has been scheduled. And they're like, what does that mean?
Especially too when it's a subpoena ducis tecum, right? Where you have to bring not only yourself, but documents.
Right, exactly. And so they're like, what do I have to bring and what do I have to do? So we actually have a great question, it looks like, from David. David's on Instagram and he wants to know, can you decline to participate in a deposition?
That's a great question, David Kukon. The answer to that is simply, from a legal standpoint, no. If you've been subpoenaed
Especially
by
if you've
the
been
other
subpoenaed,
side, you cannot elect not to show up. They're going to, try and get sanctions the other side.
Yeah.
They have the opportunity to do that if you don't show up.
Or they could move for contempt of some sort. So it's definitely something that you're required to do, especially as the plaintiff. We handle plaintiff's cases. We do personal injury. And so we're bringing these cases on behalf of the plaintiff, our client. And so as the person that has filed the lawsuit, you have to show up for your deposition because the other side is entitled to do discovery and they need to know what your testimony is going to be.
And simply put, your case could get thrown out by the judge if you don't show up to your own deposition and if you're the one bringing the case. Right.
If you don't cooperate with the discovery process, you might as well kiss your case goodbye. So hopefully that answers your question, David. So just to get into that a little bit more. So a lot of people are like, okay, all right. So we've established, thanks to David's question, that we do have to actually show up. And so once you show up, what can you expect?
Well, you can expect to be, like you mentioned earlier, it could be a Zoom format. It could be in a small room where it's just you, your attorney, the opposing counsel, and then there's the court reporter that's going to be there as well. And the court reporter is going to be taking down everything just typing down everything that's said, question answer format, from the point you're sworn in to the point it's finished. Right. So unless you hear your attorney say off the record, obviously. But and from there, it's really the other side garnering information and asking anything they want. Right. Unless you hear your own attorney say, object, attorney-client privilege, or something along those lines, then it's a free-for-all, really.
Yeah, and they have some free latitude there when it comes to the kind of questions they can ask. They can get into your treatment history. They can get into your background. They can get into your criminal history.
So we know from plaintiff cases and medical, from a medical standpoint, and our clients are talking about what happened to themselves after an injury, and the opposing counsel is asking them questions about where have you gone and treated, what medical providers have you seen in the past 10 years, 15 years. And I can see my client thinking, what's that have to do with the case?
Exactly.
But that's the type of latitude that the opposing counsel is given in a deposition.
Right. And one thing I like to tell my clients as we're preparing them for deposition is, it's not a quiz, okay? So you're not being tested. You're not going to get a grade at the end of the deposition. You obviously want to do well because it helps your case if you do and you testify appropriately. But if you don't remember, just say that, you know? I don't know. I don't recall. I'm not sure are all perfectly fine answers in a deposition. People don't always realize that, and they sit there and they kind of, try to rack their brain and remember, and they're thinking, and they're like 15 years ago, I'm not really sure, and they get all flustered, and the deposition ends up going a lot longer than it needs to because they're trying to come up with these answers. I always tell people, don't guess. We don't want you to guess because you could guess incorrectly and that could hurt your case. And, okay, I don't know, I don't remember, and I don't recall are all perfectly fine answers, right?
Absolutely, because you're right. And we don't want you guessing because also the other side can use the information you give them at a deposition later on in litigation and can use it to your disadvantage. Because if they find out something that you testified to during your deposition, they can absolutely bring it up later on and say, well, this person isn't as credible as
they absolutely will.
They are alluding to.
Right. Because like you mentioned, right, Daniel, there's a court reporter there and he or she is typing down everything you say stenographically. They have their little machine and they're getting everything word for word.
Still don't know how that machine works because it's
I can't do it. That's for sure.
It's like not a normal keyboard. It throws me off every time.
And have you seen the old school ones where they like talk into it?
No, I haven't.
Oh my God, they're so weird. It's like they're talking into the machine, and I think that that used to be a way that people did it all the time, but now you don't see them as much. But that's even harder to understand. I don't even know. I think they're maybe saying short form. I don't know. Anyway, if there's any stenographers or court reporters watching, please call us and explain how that works.
Well, to also help out, because there could be some court reporters listening. Yeah. What are some things that court reporters like from our clients when they're in a deposition to avoid some problems? Tips
with that: speak clearly. Okay. Don't talk over the other person. So the attorney that's deposing you or asking you the questions is usually going to try to give you the courtesy to, finish what you're saying before they ask you another question. So I always tell my clients, give that same courtesy. Wait and get everything out. Wait till the question has been asked before you start to answer it, right? And there's reasons for that. If you don't know what the question is, and you start answering it before it's actually done, you might answer it incorrectly. So wait for the full question. Give yourself time to think. Pause after every question, then respond. It makes the transcript a lot clearer. And then you also know that you understood what the question was. And court reporters, it's just very difficult to take down two people talking at the same time. So it's better to just wait, hear the whole question, let it be asked, then respond. But don't answer the question if you don't understand it, right?
Mm-hmm.
I definitely tell people that all the time. Don't answer a question you don't understand. Ask for clarification. Ask for it to be repeated. And I can guarantee you, I don't know who's sitting on the other side, but that lawyer wants you to give a clear answer as well.
Yeah, I mean, like I mentioned previously, they are listening to everything that is being said at the deposition, and they're trying to trip up our clients and trip up the other person on the other side. We do the same when we're deposing defendants. We're trying to trip them up and get them to say something.
Yeah,
it's all about when you take a deposition from a lawyer's perspective, you're really looking for one or two key points, key phrases to get the other side to say, and then it's a successful deposition, right?
Exactly.
You're not looking for a home run and to prove the entire case. You're just looking for that one little snippet that you can take. So, and that's what the other side's doing, apart from just getting information. This is really their first chance to listen to our client or plaintiffs in general and go from there. Because right after, I know from a plaintiff and a personal injury perspective, right after the defense counsel is informing their boss, which is the insurance company, on the credibility of our client,
they're evaluating,
on the appearance of the client, on everything. So
when I was in law school, I clerked for an insurance company, and that was actually part of my job. I was obviously wasn't a licensed attorney, so I couldn't take the deposition, but I could go sit in and watch them, and that was kind of what I did, was sit in and watch the deposition and evaluate the plaintiff and determine, is this person likable? Do they answer the questions well? Can we kind of press their buttons and get under their skin? Do they present well? If we took this case to trial, how would a jury view that individual? And that's exactly what I tell my clients when we're preparing for a deposition. I say, look, the defense lawyer is not just asking you questions. They're there to see, how is this person going to do if we take this case to trial? Is the jury going to like them? Are they going to be sympathetic towards them? Is it somebody that they're going to want to, feel sorry for and award money to? Or are we going to be able to push their buttons and make them look bad in front of a jury? So how you compose yourself and answer questions during a deposition is really going to impact what they think about you, moving forward with the case.
Absolutely. And now that you're kind of going along those lines there, I'm thinking back to all the depositions I've taken of just nightmare, not nightmare clients, but
they didn't go well.
They just didn't go well when I had in the Zoom era where everything was Zoom. Now we're getting back to some depots being in person.
Sure.
Most are still over Zoom. But right out of law school, so this was probably 3 years ago, one of the first depots I ever done, the client of mine, it was Zoom, and they get on the Zoom and they were in bed with the covers on, and I go, the other
Laying
side's
down.
there, they're laying down, they're all snug, right? And I'm like thinking, oh man, they're not, the opposing counsel is just not going to take anyone seriously about their case when you're clearly not taking it serious yourself.
Yeah.
So
and that has definitely been the worst thing I think about virtual and remote depositions, is that people come in their pajamas or they're in their car driving, smoking cigarettes, doing whatever, when they don't realize that the other side is actually looking at you and evaluating you and judging you, on how you will appear. And you want to put your best foot forward in deposition. So I always tell people, dress nicely, be comfortable, but dress nicely, be kind. It's not a fun process, but be respectful and, listen to your lawyer.
Yep.
Yeah.
And another tip I like to give my clients as well is answer the question and only the question, right?
Oh, yeah.
Because
do not volunteer information.
Exactly.
Yeah.
Because a lot of times people, and not everyone has given a deposition before, obviously, and people have a tendency to ramble when they're in uncomfortable situations. And when you ramble, you just offer information and
too much, and it's never
too
good
much.
Stuff.
Yeah.
People think that they're helping themselves the more that they say, and that's usually the opposite. I tend to find the people that say the most and talk the most during their deposition do the most damage. There's a way to be short and sweet and to the point without being rude, and I think that's the art of it is, you can be kind and respectful, but still be concise with your answers. If you can keep it to a yes or no response, beautiful.
Exactly. I mean, you don't want to say, if the question was, were you injured in the year preceding to the accident that you're here about today? Yes, I was. Okay, let's talk about that accident. You don't have to say, yes, I was. And then I was also injured 5 years before that, and then 10 years before that. And
start going into the whole dialogue about all the injuries when they didn't even ask about it yet.
Exactly.
Let them do their job. So that's another thing I tell my clients. Don't come in there and do the job, the defense attorney's job for them.
Mm-hmm.
They're getting paid to do a job. Let them ask you the questions. And if they need more information, they'll ask.
Mm-hmm.
You don't volunteer it. So I think that's something good to remember is just keep it short and sweet. Don't volunteer anything. And my number one rule, I don't know about you, is tell the truth.
Oh, of course.
The truth never changes.
Of course. And the truth will set you free. And that's absolutely true, right? I mean, because look, we don't like to file what's known as errata sheets because you can correct deposition testimony through an errata sheet. We don't like to file those. We'd rather just everything be correct the first time.
Exactly.
Because when you file it afterwards and make these little corrections to the deposition transcript, it leaves a bad taste in the opposing counsel's mouth. And
it also opens the door that them have to get to depose you again.
Exactly. If it's that severe of a change, absolutely.
Yeah. If you make really big changes to your deposition transcript, they can go back and depose you again about those things.
Mm-hmm.
So if you don't want to have to do it twice, you want to make sure you try to answer the questions as best as possible and without leaving out, major information.
Yeah. And most of the times you will only have to do it once, but on the the lengthiness of litigation. Sometimes if you have updated treatment or something like that, you would be forced to come back again and
It's
to give
possible.
an updated deposition. So
Exactly.
that's also an option for the other side to have. But in regards to depots as well, I also tell my clients not to criticize either the opposing counsel or doctors of their own.
Oh, sure. Yeah.
Or because it does leave a bad taste and goes to.
And you're asking a jury to pay for your medical bills. And so an injury case, if you've seen the doctor and let's say this doctor that you've just bashed or criticized has a bill for $5,000 that you want to be paid or how X amount of money, and you've just said that he was no good or he didn't do anything for you or the treatment didn't help. Well, now you've just given the defense a great basis for not paying for that treatment.
Yeah,
didn't do anything for you. It didn't help you, or the doctor didn't know what he was doing,
Yeah, so it's just better if you avoid that.
Yeah.
And really the only time in a deposition you don't answer a question is when your attorney pipes up and
Right.
talks about privileges, right?
Exactly. So
And
you can obviously explain what some of those privileges
and
are.
attorney-client privilege is basically what you tell your attorney in confidentiality.
Mhm.
That is basically attorney-client privilege.
Totally off limits.
Totally off limits for the other side to try and pry out of you. Oftentimes because we do personal injury work, we get clients that come to us, don't really know any doctors in the area. We say, okay, here's some providers that can help you. And we would refer you to a provider. That right there, that correspondence between us and the client there on telling where to go, that is protected by attorney-client privilege, to name an example of that.
Maybe not so much under the new laws, though.
The new laws changes things.
There might be some changes now.
This is before March 24th of 2023.
Right. There's some caveats to that now. But that's true. So there's attorney-client privilege, and there's also accident report privilege.
Yep. Accident report privilege. In Florida, it is essentially when there's an accident and a police officer comes out to the scene, because it's their duty to collect information as to what happened, who caused the accident, and people, when they see a police officer, are kind of wary of them.
Mm-hmm.
So they offer information, give up information. That is then whatever is collected at that scene is what's known as accident report privilege. If it's a requirement for the police officer to fill out the accident report.
Right. Now, if you're a witness to an accident or you're the passenger in the vehicle, then that privilege may not apply to you. I believe the case law says
it does not apply.
Does not apply to, non-drivers of the vehicle. So
it's statutory, I think.
Right. So if you are just an independent witness, you just happen to witness a car accident and you're called in and subpoenaed to come in and give your testimony, then anything you said to the officer at the scene could potentially be asked. Is not going to be protected. But if you were one of the drivers of the vehicles that's involved in the accident, then that privilege would apply to you.
Mm-hmm.
Yeah. So obviously we spent a good amount of time talking about depositions. And so I think it's probably a good time to take a quick break. We've got some more awesome litigation tips for you after the break. Feel free to give us a call. We want to hear from you. The number is 441-3000. We're going to take a short break and we'll be back in just a minute.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
Listen to the latest pet trends with benefits on the Pet Buzz every Saturday morning from 9 to 10 a.m. Join pet trendologist Charlotte Reed and veterinarian Dr. Michael Fleck as they talk all things pets. From animal health and wellness, money-saving tips, celebrity gossip, breaking news, and more. Their expert guests are in the know and in the now. To learn more about this unique program and its hosts, tune into the show on the Tan Talk Radio Network.
Hello there, Tampa Bay. This is former NFL and college football coach Jimmy Johnson. Listen to the Kelly Show every Monday starting at 5 p.m. They can sure use the attention.
And this is former Major League Baseball player, Hall of Famer Wade Boggs. I also hope you listen to the Kelly Show every Monday starting at 5 p.m. They can darn sure use the money.
Hi there. This is marine wildlife artist and conservationist Dr. Guy Harvey. Please listen to the Kelly Show every Monday starting at 5 p.m. They need to feel worthy.
This is the Tan Talk Radio Network.
And we're back to FLA Law live on the radio, and we are here still to take your questions on our legal talk show where you can call in and comment or ask us questions about any legal matter that you have. As we know, we are personal injury lawyers, so that's kind of the topic matter that we stick to. But of course, feel free to give us a call about anything that you have questions about or comments. The call-in number is 441-3000. And again, this is FLA Law on the radio. I'm here with my co-host, Daniel. And of course, before the break, we were talking about litigation and, going through that lawsuit process. And one of the major things that comes up was deposition. So now I think it's a good time to kind of transition our next point into different tips or pitfalls that can occur through social media posting, going on vacations, trips, your kind of online activity, and how that might play into your lawsuit.
Yeah, I mean, oftentimes in personal injury cases, you are obviously proving an injury from a plaintiff perspective.
Right.
It applies to every other type of case, but I'm just thinking from a personal injury standpoint. And you're claiming injuries to your low back, to your knee, to whatever it may be. And then what if you post on Facebook, that is a public Facebook account, that you're on vacation on the beach somewhere on a boat, and you're going up and down on rocky waters, and your knees sustained well, and you're having a great time. It looks like from these photos.
Oh, yeah.
You're drinking, partying, and the other side is going to see that.
Exactly. And I always tell people, I don't even know that it has to be public these days. I mean, anything that you put on the internet, you should assume that there's a way that they can get it.
Mm-hmm.
And even if you have your profile set to private or friends only or whatever the case may be, you should be aware that could still get into the hands of the insurance company. They have their ways, they have their investigators. I can't necessarily say how they do it, but they can do it.
Yeah, I mean, they're just going to send over a request to produce for that information, and oftentimes, first thing they do is ask at the deposition, like we talked before the break about depositions. They'll ask what vacations you've been on, and then they'll try and go from there afterwards, see if you've gotten any photos of those vacations that they can get. So things like that. And
so the life has been made easier for defense lawyers because of social media. I think, before, you may not have had vacation photos or videos of your vacation, but now everybody posts everything. I mean, people post stories, reels, TikToks, Snapchats, you name it. And they post, a vlog of their travels or parties or whatever the case may be. And that's always been what they did. And they don't realize that now that you have a lawsuit out there, those things can come back to bite you. People also don't realize that they might post old videos and old content, but people might assume that that's recent and that you're doing that right now. And so it's very something that you very much want to pay attention to is, what am I posting and how is it going to look for me in my case?
Yeah. And on the flip side of that, oftentimes our clients come to us and are like, well, just because I did this, I mean, they didn't see the actual footage of me at the amusement park, at the beach, where I had to sit down every 5 minutes because I was in so much pain, which could be true as well. But it just is the perception of the other side. So that's why the social media thing comes up quite a bit.
And that's exactly right, because they don't get to see when you got home that night and you had to, take an ice bath or elevate your feet, or how swollen your ankles were, or how much pain you're in and how many extra pills you had to take just to knock out the pain. They won't see any of that. All the jury is going to see are these photos or these videos that you posted where you appeared to be fine and you looked great. I remember there was a case that we tried. A young guy had a very bad herniation, lower back, and for his age, you wouldn't expect someone at that age to have such a, largely extruded disc in their back, right? But he posted photos on Facebook of him doing different sports and things like that. And that the jury got to see those things. And so they don't realize that he might be limited now in the things that he can do. And maybe he can't do it in the same manner that he used to. But because he posts, a video of him out there doing that, it looks like he's fine, and it makes him seem as though he's okay.
Yep. And it's more than just social media or Facebook or Instagram or things like that, right? As I wave into the social media and the live Instagram we've got going on. But it's more than that, because your story there just reminded me of a client. He had what's called a Strava account, which is for biking and can log all your bike rides.
Oh, okay. Never heard of it.
Yeah, it logs all the bike rides. It's like kind of like one of those it's like similar to what an Apple Watch does, where you can log your exercises, or your long distance runs. It's a Strava account where you can log your long distance bike rides. And
so they send a request to produce for that.
Well, it was public. Like a simple type onto Google for the Strava, and it came up all of my clients' bike rides from the past, and unfortunately, like it doesn't take into account how many times you stop or whatnot, but it showed the time and the distance, and the other side, the when we were negotiating, the other side did not take too kindly to that information, and actually negatively affected the case. So it's anything that goes on the internet that could potentially harm you from a personal injury standpoint.
It's always out there and it can't be deleted. So people think, oh, well, I'll just take that post down. No, you're actually now destroying evidence. So
if you're in a lawsuit, it's spoliation of evidence, right?
Exactly. You can't delete the post. You can't destroy the profile. And there's also ways to recover that. So there's, different settings within the profiles that you can go back and get that information. And a judge could order that you go back and restore that profile so that they can see what was posted. And if you're in Jamaica, going ziplining, and you testified in your deposition that my back hurts and I can't walk long distances, but you're climbing up, that waterfall in Jamaica that everybody goes on. Yeah. It doesn't look good for your case.
And it doesn't look good to the jury, right?
Exactly.
It just doesn't. And, we're obviously not telling plaintiffs that they can't live their lives. It's just a good idea to not put on social media.
Right.
And you can actually...
Because of the perception, right?
Yeah. And you can actually see it from the Gwyneth Paltrow case that just got decided.
And she won that case, right?
She won
got
that
a
case.
verdict.
And I was reading, I have the article in front of me right now, that the plaintiff in that case, the doctor, I think he was an optometrist or something like that.
Right. Retired eye doctor.
Yeah. He was alleging that he suffered traumatic brain injuries because of the accident. But after the accident, he had the Facebook photos played a massive decision and role in the jury's decision, actually. So the Facebook photos and posts presented in court showed the plaintiff riding a camel in Morocco, trudging up to Machu Picchu in Peru, ziplining and bike riding, hiking with his girlfriend, doing Zumba, playing mini golf, exploring an escape room.
So these were the plaintiff's photos during the Gwyneth Paltrow trial.
Yep.
So
While
after his injury, he went to
after his
Peru.
injuries, all these Facebook photos of all of these vacations came about, and the other side presented it during trial. And the jury actually, they interviewed some of the jurors, and they said that was a massive effect on their decision. So, and
I heard the jury actually reached a verdict in that case in like 20 minutes, but it took them like 2.5 hours to go through the verdict form. But they literally had decided within 20 minutes that they were going to find in favor of the defendant, which was Gwyneth Paltrow in this case, and that she wasn't liable for his injury. So that is pretty compelling. Mm-hmm. That tells you, we have a comment on social media, good information about social media. Thank you, Sunita. So that's compelling. That tells you that jurors are often skeptics, and they are looking for information that will help them decide, is this a true injury or not? And if they see these social media photos, they think that that's an accurate representation of who you are. And not just social media, because they can ask in your deposition, any vacations have you taken? Even if you didn't post them, you still have to be honest about where you went, where'd you go, what did you do, how long were you there, what kind of activities did you participate in? So it's you should be mindful of what you do after your injury. Mm-hmm. Even if you say, somebody out there could be listening, like, I don't even have social media. I don't even have a Facebook. So this doesn't apply to me. Not true. Mm-hmm. Because if you're like an avid cruiser and you go on a cruise 3 times a year, but you never post about it on social media, trust me, you're going to have to talk about that in your deposition. And they're going to ask you, where have you been since the fall or the accident? And you've got to testify truthfully.
Yeah, it's going to get brought up during your deposition if you are lucky enough or unlucky enough to make it all the way to a trial. Mm-hmm. It's going to come up at trial, and they're going to ask you about all your vacations you went on, all the trips you've been on, how long you've been in the car, right? Mm-hmm. We see that quite often. Oh, you were in a road trip. So you were able to sit down and drive a car for 4, 5, 6 hours, right, and you didn't have to take any breaks. Oh, okay. Mm-hmm. So it always comes up.
It does. And I think it's even more, smaller than that, not just sitting in a car, but the shoes you wear. I had a defense lawyer once looking at my client's high heels and how high the heel was in her photos that she had posted where she was, out and about, and she's wearing these really high stilettos. And, part of her claim was that she had hurt, her knee or what have you. And so he wanted to talk about how your knee pain plays in the fact that you can still wear 3 or 4 inch heels.
Well, that just goes into surveillance now, too, mm-hmm. if we want to talk about that.
Oh, yeah, go ahead. Let's talk about it.
I mean, with litigation and from a personal injury standpoint, when you file that complaint and you get in a lawsuit as a plaintiff, you best believe the other side's going to send out some sort of surveillance to get on you from an investigator.
It's very common.
And they're going to be videoing you you don't know when, because mm-hmm. I've seen
various times of the day.
I've seen surveillance footage from crazy situations that you wouldn't even expect someone to be there videoing you. So
going back to my law clerk days when I clerked on the other side at the insurance companies. And I remember that was another task that I was given, to watch hours and hours of surveillance footage to see if there was anything good. And when I say good, I mean bad for the plaintiff, but mm-hmm. good for the insurance company. And I was stunned at this one surveillance video that I watched. They actually followed this guy out of the state onto his vacation. So he was filmed getting into his car at home, loading up for vacation, putting all the suitcases and things into the car. Not only did they capture that, they captured him and followed him all the way down to wherever he was going. I can't recall at the time. I think it was somewhere in Georgia, a water park of some kind. filmed him at the water park, filmed him on the rides.
Oh, no.
And it literally was hours and hours and hours of footage. And this person, who was obviously a plaintiff who had brought a claim, had no idea, didn't seem to be the wiser that he was being watched the entire time he was on vacation. And here I am going through the footage, at the time for the insurance company that I was working for as a law clerk, looking for what I can find to use against him in that case. And so that's exactly what the insurance companies will do.
And most times the surveillance is ordered by the defense right after the deposition, so they can lock the plaintiff into a position, whether it be, I can't walk for more than 15 minutes. I can't bike for more than 5 minutes, something like that.
Exactly.
And then they'll get the investigator out there to take some footage to see if those are consistent statements or not.
Exactly. So another tip, I remember that's exactly what that insurance company did that I worked for. Right after the deposition, the plaintiff and their attorney would leave the room. The defense lawyer would get on the phone with the investigator and say, he or she's in a white car, they're wearing a pink shirt, and they're walking out of the building right now. And that's how it would go.
Yeah.
It was literally somebody sitting in the parking lot after the deposition waiting for them to walk out. Follow them. Because otherwise they don't necessarily always know what their schedule's like, but we do know they're at the depot right now, and they're going to walk out of the building. So follow them. And that's what would happen a lot of times.
Yeah. A lot of times what I see from a personal injury standpoint, again, with our clients claiming low back pain, and oftentimes with low back pain, you can't crouch down or you can't bend down to get something. I've seen surveillance footage of investigators following our clients into a Publix, into some convenience store with the camera right in their front. I don't even know where it is on these investigators. And they'll take a video of our client bending down to the bottom shelf to collect an item.
Right.
And then boom, that it hurts your case.
Exactly. And what you won't see is I've had cases where my client, that happens, but they're wearing a back brace. You can't see it because it's under their clothes, or they had just taken, their pain medication right before. And so they were able to do a little bit more than they normally would have. But these are the things a video won't show.
Perception to the jury.
Surveillance won't tell you any of that. So that's why it's really important to be mindful of what you're doing on social media, what you're posting, how it appears. And here's my rule of thumb. If you don't want to see it in a courtroom, then don't post it. If you don't want a jury looking at it and the judge viewing your content, then don't post it. And trust me, I know there's a lot of things that people post that they would never want a judge or a jury to see.
Yeah. It just comes up. It just comes up. And I know from a right when you start a trial, you go through what's called voir dire, right? Where you have to select the jury.
Right.
Oftentimes juries and people just are curious. And what's the first thing that they'll do? They're told not to, but what's the first thing that they'll do? They'll look up the client.
They definitely shouldn't, but yeah.
And see what this person's all about. And they shouldn't. They're not supposed to. They're not allowed to, but they do. And it's sad, but then they'll, if they see political viewpoints or something like that they don't align with, they'll, take bad, positions, and that's not right.
So I always tell people, if you have a lawsuit, you've been injured, you have, retained an attorney, stay off of social media, right? So, and I think another tip that we want to talk about that's really, really important and key, especially in injury cases, is, being forthcoming with your attorney about your past history. When you've been hurt before, or you've been in other accidents, you have brought other claims, you've been sued, or you brought other lawsuits, but you don't tell your lawyer, you are setting yourself up for failure.
You're killing your case, and your lawyer is not going to be very happy with you when they find out.
Yeah.
Because from defense perspective, then when they see prior accidents, prior claims, their headlights go off. They're doing
it's
all
Christmas
sorts.
morning for
It's
them.
Christmas morning. They're doing all sorts of discovery. They want to know all about these previous cases to see if they are the same accident or the same medical condition, the same injury, because they can say that it's related to this accident, not the subsequent accident that you're now being represented for by that new attorney.
Exactly. And a lot of times, plaintiffs don't realize, they're like, oh, well, that was old. I had a different lawyer. It doesn't matter, different injury, not the same as this. But that does matter, because those records, we need to see what was said. What did you tell the doctor was hurting? What body parts were injured? How serious was that impact? Was it a rollover? Your car flipped 3 times, the airbags deployed. These are the things we want to know. And you don't want to be in a position where your attorney is being surprised by this information. As much as we try to explain that to our clients, but we don't want to be constantly playing defense,
Yeah, we'd rather be on the offensive for sure. And when we get surprised by information, and that's why the other side wants it too. Now, because if it's 10 years ago, people don't realize when they're doing it. I don't think the clients, but oftentimes I don't know what I said to a doctor 10 years ago.
It's easy to forget.
I could have said my knee hurt, and I wasn't even there for my knee. I was there at an eye doctor, and I said something about my knee. Yeah. Well, that eye doctor might have put something in those records.
Yeah.
So. And
you documented it 15 years ago, totally forgot. And so those examples I think aren't as egregious, when you're entitled to have a lapse in your memory here and there. But when you are purposely trying to, minimize or, not disclose that information, it can come back to bite you. And it could come back to bite you in the form of a motion to dismiss for fraud on the court. So if you don't want your case to be thrown out, for being dishonest about your past medical history or your past, litigation history, then it's best to just be honest and upfront. Tell your lawyer about it so your lawyer can try to deal with it in the best way possible.
Yeah, because from what we do is we would shift our focus from proving an accident, and this was all suffered from this accident. There was new injuries, to just saying that it's an exacerbation of a previous injury, this new accident. So
right, and we have to just get your doctors to explain to us how it, aggravated or exacerbated the injury, and not necessarily looking at it as a brand new thing. And your doctors need to know that too, because if they're evaluating you and they have no idea you've been hurt before in the same area,
they can give wrong medical
they can give
treatment,
incorrect, advice or inaccurate opinions.
Yeah. I mean, it's just so bad for a plaintiff when they're in a courtroom and they told their doctor one thing when really they had been suffering from this injury for years and years on end. There was previous injections, previous treatment that this doctor didn't know about. And he thinks all of this medical treatment stemmed from this one injury that we're here about today, the most recent injury, when there was something way in the past.
Exactly.
So he just kind of looks stupid in front of a jury. And as we know from a jury and how they analyze things, it's the expert that really is pivotal when they're making their decision.
Right.
And who has the better expert.
Exactly. Not to go back to Gwyneth Paltrow again, but I think that was another deciding factor too. I think a lot of the jurors that they interviewed after the fact, the ones that were willing to talk, said the same thing, that they actually felt that her expert had the stronger science and the stronger testimony. And that's what they really went with when it was time to decide, is that doctor that was testifying on the defense, on her behalf, just was the stronger expert. And I think that's true for juries. They look at the science and the medicine. And if you have put your own expert in a position to not be able to testify in your favor because you didn't give them all the information, and now they have to kind of fall on the sword. So it's just better to be honest up litigation. be honest and upfront. Things up about a little bit of a current events. I know we
about
are whappers and they but he has now appealed to assist him with his appeal.
when you're trying to appeal for but well, I guess we'll see.
Was denied. The judge, there were some years thrown out there, and it was a lot. Like,
And this is the criminal side of things, right?
Yeah, this is a criminal case. I know that she's suing him civilly.
I was about to say, yeah, and there's this misnomer that people think that it's one or the other.
Right.
But you can
separate actions.
File a criminal case, and you don't file it. The state would go for a criminal case against you, the defendant, when you're commit a crime.
Yeah.
But then there's the civil side of things where the person you commit the crime against, in this case Megan Thee Stallion, she can go after Tory Lanez for shooting her in the foot for an intentional tort.
Yeah.
So I don't know what's going on there.
She could, and she probably should.
I mean, if she, I can't imagine that being fun, getting shot in the leg. So
yeah, and then he maintained his innocence for all that time and denied it. But it seems like the evidence was pretty compelling that he did it, and I think I can officially say that he did it because he was convicted. Yeah. So with that being said, as you know, we are personal injury lawyers at Pernick, Caulfield, Averill, and Noyes. We are here locally in the Clearwater area. This has been our show FLA Law live on the radio. We thank you to all our callers and listeners. Any last words, Daniel?
None from me. Hope everyone has an awesome rest of the day, and see you next week.
See you next week, Tuesday at 5 p.m. FLA Law on the radio. Thanks, guys.